This morning on the Ag Issues program, a pleasure as always to bring back to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks. Good to be with you.
Well, we've got a lot to talk about, and I won't say hodgepodge, that's not the right term, but a lot of specific issues to discuss. And, I'm sure one of the more common questions that you get involves disputes concerning fences, but there's several ways that it can be discussed, but I can't even imagine how many of those issues that you've been involved in.
Yeah, I get a lot of those. It's almost as if, well, when I fire up my email each morning, how many fence questions am I going to get? It's incredible, the scenarios that can occur with respect to fences. And so fences do make good neighbors. Bad fences make bad neighbors. I think that's, we've heard the first part of that, but maybe not so often the second part, but it's equally true. But fences are critical to agriculture, and we get disputes over fences. And I'll just say it was a week ago Friday, the Iowa Supreme Court completely messed up a fence case dating back to statehood. And last weekend, I spent time rewriting the applicable state statute, and there's going to be a bill filed in the Iowa legislature this week to erase that Supreme Court opinion. I mean, it was so bad. What happened was you had a boundary between a couple of different tracts that were farmed by different people, and then the same tenant acquired those tracts. And there had been an old fence, never been removed, but it was down. And so people are familiar with old fences that end up in the ground, and you find pieces of them, and the corner posts were still there. There was a brush line. So the two tracts were separately demarcated. There was no question about that. Well, long story short, you end up with different people owning the other tracts, and those tracts had been sold off of the property description, which was that old tree line, that brush line, and where that old fence had been. So the buyer knew what they had bought, and the seller knew what they were selling. There's no question about that. That had been used that way for decades, and this is often what we see in agriculture. Well, the buyer of the one tract, the new buyer, decided, well, I'll have a survey done. Well, lo and behold, the survey was over on the other guy, who, when he was tenant of that property, put up a machine shed on there. And so this new guy said, well, that's my property now, because that machine shed's encroaching upon me. And when you know it, the Iowa Supreme Court said, yeah, that's right, totally ignoring historical use of the property, which is absolutely incorrect according to the way the statute has been interpreted back into the 1800s. So we're hoping to get that decision by the Supreme Court completely wiped off the books. But that's one scenario that you get into. But what I tell people in terms of disputes, and this is another issue that often comes up, how do I resolve this dispute with my neighbor short of going to court? Well, a good place to start is by checking land records. See if by chance any prior owners at any point in time in that chain of title had recorded a fence agreement. And if they did, that agreement's going to bind that person and their neighbor. Now, chances are there's not. I think in the 32 years that I've been doing this, I've seen 2 written fence agreements anywhere in the country. So they're rare, but always check the legal records first to see if there is a fence agreement. If there's not, and there probably isn't, you could execute a new one and have it recorded with the County Register of Deeds. And once it's recorded, it'll bind all the future owners.
And there, as a last resort, so to speak, is there a way to maybe have someone come out and take a look at that? And I don't know what they're called, not an arbiter, but nonetheless, someone who could visually look at that?
Yeah, they're the fence viewers. And every state rule has a different set of statutes with respect to the process that you have to go through to call the fence viewers. And in Kansas, they're the county commissioners. And sometimes that's even a surprise to some of the county commissioners that they end up being the fence viewers, particularly in the 4 or 5 primarily urban counties that we have in Kansas. And in fact, it was about 25, close to 30 years ago now. I distinctly remember a picture on the front page of the Topeka Capital Journal of a brand new elected county commissioner for Shawnee County. and it was a lady, and I remember the picture. She had a pretty dress on, had high heels on, and it was a picture of her out in a pasture. And the comment was, I had absolutely no idea that I had any responsibility to do anything like this. And I got a chuckle out of that. I filed it away someplace, probably so good that I can't figure out where it's at. But that was in the close to the 1993, 1994. But the county commissioners are fence viewers. In other states, it might be the township trustees. But there's a process to go through to request them to come out and make a view and a determination of responsibility. Now, under Kansas law, and this is the way it is in most states, they only have jurisdiction on determining building and maintenance of a fence, not boundary issues. Boundary issues are legal issues. So they don't have any jurisdiction over that. But if you've got a fence that is in need of repair or one that needs to be built, that is an issue that is for the fence viewers to decide the allocation and the responsibility of that. So know the process. I get a lot of questions with respect to that. Those issues come up all the time.
Another issue that many have talked about or have been involved in would be agritourism, and the majority of the states do have laws that are designed to provide enhanced liability protection for injuries to participants or spectators associated with the inherent risk of a covered activity as well. But there's a lot more to this issue too.
Yeah, this is something over the last 20 to 30 years that the states have really ramped up on in providing some legal liability protection through a state statute to incentivize farmers to open up their property for non-farm folks, city folks, to come out and enjoy recreational activities and tourism activities, what we call agritourism, on those farms and ranches. So it's usually the agritourism statutes, and indeed the one in Kansas, has a very broad definition of what is agritourism. So it'll include such things as corn mazes and hay rides and tours and roadside stands and similar activities. And so what it does is if you are encouraging people to come out to your property to engage in these types of activities, then we want to give you an incentive through the legal process by limiting your potential liability if there are injuries that occur to these participants, these entrants, while they're on your property. And so you only will be liable for gross negligence, willful negligence, what the law calls wanton negligence, but simple negligence you would not be responsible for. Now, you may be required to post warning signs to get the protection of the statute. You also might be required to register property with the state. And in order to get the protection of the statute in Kansas, you do need to register with the state. And that's a cost-free process. And so there is a branch of Kansas government that handles the tourism activities. And you can register, and they'll give you the proper signage that you need. And so on the liability issue, then, you are generally protected, except if you willfully injure someone. And you may want to have your participants sign liability release forms, and you may state law also might provide tax credits and protect the property's ag tax classification, and that's something that varies from state to state. So that can be a good way. These agritourism activities can be a good way for farms and ranches to generate additional income, but you do have to make sure you know the details of the state law.
Yeah, because they don't have, or many states don't have, the estate tax problem. But if the exemption drops, then that's a different story.
Yeah, that's a side issue. What I'm talking about here on this one are state income tax credits. But that kind of bleeds into the next topic we were going to talk about, and that is a lot of these farms and ranches. It's important to have that additional stream of income because you may have a liquidity problem. A lot of farmers have decent asset values or high asset values, a lot of good net worth, but not sufficient cash flow or liquid assets that they could tap into if they have an emergency or they need to pay certain costs. And so having this additional stream of income from agritourism activities can help. And this liquidity problem will be more pronounced if Congress doesn't do anything, and that federal exemption, as you hinted at, from federal estate tax comes down starting in 2026. So you got a number of things to think about as the operator of a farm or rancher. What can I do to increase my cash flow? And then if I've got high asset values, but they're not liquid assets, does that liquidity problem present a problem for me, particularly if the estate tax exemption comes down? So a lot of things to think about there.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest this morning. And Roger, moving on, and I'm sure if your local county has seen some type of this particular issue, the local zoning rules leave the door wide open to the potential for farmland to be converted into usage for solar panels. And that's an issue, boy, like I said, you could go county by county, and I'm sure, and you've probably seen many cases associated with this.
Well, I'm starting to see more and more of them. It's kind of a repeat of what happened a few decades ago with wind energy, and the counties were caught off guard. They didn't have any rules in place with respect to the development of commercial wind. I hate to use the word farms because they're not farms, but in industrial wind operations. It's the same thing with solar panels. There aren't any rules in place that deal with these massive use of solar panels. We've seen the issue heat up most recently in Douglas County. That's one right next to us here in Topeka, but it's occurring all over the country. So counties are going to have to get their arms around this and figure out what they're going to do, because the problem is with the doors wide open and no rules in place, there's no extra step that's required to go from agricultural land to solar use of that land for solar panels. And some of this is occurring on prime farmland, which in my view should not occur at all. That is not a good use to take prime farmland that is the base of our food supply and put solar panels on there. But leasing farmland for the placement of solar panels can destroy the land's potential to return to farming. And that's because, and I'm not sure people realize this, but often fine sand is spread on the farmland where the panels will be placed to kill off plant growth under the panels, so you don't have a weed problem. Well, that doesn't happen in every situation, of course, but where that does, it destroys the possibility of growing anything in that field again without incurring significant remediation costs. And people need to be aware of that. And solar energy agreements, I've looked at these contracts, and I have a couple more on my desk right now. They may only require remedial work at the end of the contract. And one I'm looking at says that's 50 years in the future. And there's a study out there that I found that has forecast that 83% of solar energy development will be on farm and ranch land unless the current governmental policies are changed. And about half of that amount is projected to be on the most productive soil that we have in the country. So there's a problem there. And really, this comes down to the local level, I'm convinced. Local zoning and planning commissions have to be at the forefront of this issue. And again, this is my view, but rezoning or permitting, I think, should be necessary to convert farmland to solar fields. Because that's an industrial use. That's not an ag use. That's an industrial use. So really, that should require some type of zoning change. And traditionally, that involves a public process. So that gets the public involved in the process. And I think that should be the case here. But this is just kind of a heads up to these counties that you're going to get faced with this, and you better be ready for it. And the ones that are faced with it already are realizing that this is not something that they anticipated, and they don't have the rules in place. And so that's a process they need to get ahead of.
All right, as we start to wrap up, I know this issue, you don't necessarily get this every day, but occasionally time to time you get this, including the one as far as Kansas is concerned, and it has to do on the issue of a landowner's duty, if any, if they need to trim trees and brush near roadways. And the question is, if a tree falls on your farm falls into an adjacent road and potentially cause injury.
Yeah, there was a case, Greg, a few years ago in Kansas, in southeast Kansas, where the allegation was, well, you didn't trim your vegetation near the corners of this county road, and individual ended up at an intersection running into somebody else, and so they tried to sue the farmer for that. And the court said, no, you've got a duty to drive responsibly, and that means in accordance with the conditions. And so if you don't have great visibility around a corner, then slow down so that you can look and determine whether anybody's coming before you cross the intersection. Well, the same issue came up in a recent Texas case, and it was a windstorm that uprooted a large oak tree on a farm, and it fell across a road. And a driver hit the tree and sued for injuries. Well, as I'm reading this case, actually it was the driver in front of her that hit this tree and rolled off into the ditch, and then she was behind that car and still ran into the tree. So she claimed the farmer failed to inspect her farm to ensure that objects on the farm would not be a hazard to motorists. And the farmer replied, said, look, there was no evidence that the tree had any type of rot or would fall. I'd never gotten any notice regarding problems with the tree. And here's an affidavit from an arborist that says the tree was healthy and would have required tremendous wind to blow it down, which is what happened. Well, this gets into court. The court rules for the farmer and said, no, there's no duty to parties that are injured off premises because the farmer's not in possession and control of those areas. And the court said, you don't owe a duty to make an adjoining road safe or to warn travelers of potential danger. Now, the court did point out there can be exceptions to that, but none of those applied in the case because this was a rural area. There was no evidence that the farmer knew or should have known of the danger posed by the tree, and any potential danger wasn't evident by looking at the tree. And again, I come back to what I said earlier. Motorists have a duty to drive according to the conditions, and that includes, Greg, being able to spot a large oak tree blocking both lanes of a road in time to avoid hitting it.
Indeed, indeed. So, Roger, as always, you're very busy during the summertime. Where are you headed next?
Back to Missouri. We just finished Branson week before last, and I've got Missouri CPAs next week in Columbia, and then off to snowy places, Jackson Hole, Wyoming, in early August. I've got some other events. I've got Hayes, the Western Kansas State Planning Council in July, but then we get to go to where there are piles and piles and piles of snow in Jackson Hole, Yellowstone, Wyoming. If you've seen the pictures of that, they're still running snowplows, and some of the roads are not open. And in fact, one has collapsed down a canyon and can't get through to the backside of the Tetons right now. But massive amounts of snow out there. It's hard to believe that when it's 100+ degrees here today.
Yeah, no kidding. Right. And if people want to see any of what we discussed, it's up on your blog?
It's up on the blog, and I'll send it over to K-State this morning.
All right, sounds good. Roger, as always, I appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.